In this presentation, we're going to look at individual rights under the Constitution, which is found in Chapter 1 of your book.
First constitutional amendment we're going to look at is the Fourth Amendment to the Constitution. And this amendment gives the rights of the people to be secure in their persons, houses, papers, and effect against, key thing here is unreasonable search and seizure. It didn't say any search and seizure, it says unreasonable search and seizure shall not be violated. And no warrant shall be issued but upon probable cause. And this is where we get probable cause in our Constitution. That's going to be used whenever we have to, going to search somebody or we're going to arrest somebody. Supported by oath or affirmation, in particular describing the places to be searched and the persons or things to be seized. This is the person to be seized. That's how we make an arrest. You actually seize a person when you make an arrest. Another constitutional amendment we're going to look at is the fifth one, and it says that no person shall be held to answer to a capital or otherwise infamous crime unless upon a presentation or indictment of a grand jury, except in cases arising out of land and naval forces or in the militia, when in actual service in time of war or public danger. This means that anytime that you are held accountable to an offense that is considered to be infamous crime, you have a right to be indicted by a grand jury based on probable cause. Also, nor shall a person be subject to the same offense to be twice put in jeopardy of life and liberty. This is the double jeopardy clause. You can't be tried for the same offense by the same sovereignty twice. And by sovereignty, that doesn't mean that the state and the federal government can't try you for the same offense because they're two different sovereignties. However, Harris County and Galveston County and Brazoria County are not two different sovereignties, even though they're different counties. So we can't try you in Harris County and you get found not guilty, then we're going to try you in Galveston County and so forth and so on. Nor shall they be compelled in any criminal case to be a witness against themselves. That's your right to remain silent. Nor be deprived of life, liberty, or property without due process of law. And due process of law is a key term here. This is, again, the federal Constitution. These all go to the federal government, but by the 14th Amendment, they've all been brought down to the states. Nor shall private property be taken for use without just compensation. For those of you who know a little bit of civil, this is going to be the process of eminent domain, the way we take property to build roads and structures that are for the common cause. Again, that doesn't fall under the criminal, that falls under a civil jurisdiction. Now, the Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Can't lock you away for years without trying you. And it's by an impartial jury of the state or district wherein the crime shall be committed. So we can't grab you up if you're charged with a case in Texas and bring you up to Alaska where you don't have access to the witnesses or anything and try you up there. And to be confronted with witnesses against him, you have a right to hear the witnesses against you. That you can't have a secret trial where they say, "Oh, they testified and said that you did it, so you're guilty." You have a right to confront the witnesses, which means you have a right to cross-examine them. And you have a compulsory process to obtain witnesses. This is the process you use to subpoena somebody to come testify in your favor. But the person has to be within the jurisdiction of the court before you can subpoena. You can't subpoena somebody who's in a foreign country and force them to come here. You have to find them in the area of the court's jurisdiction. And then finally, you have the right to assistance of counsel for your defense. This is your right to have an attorney. And this has been held in several areas, key areas of a criminal investigation also. Well, we're going to talk a little bit about detentions and arrest, and in the consensual aspects. A detention can occur based on reasonable suspicion, which is less than probable cause. You need probable cause to arrest somebody. And we're going to go over the different levels of proof in just a moment. When you make a formal arrest, you are going to need that probable cause. Now, you can stop someone without any suspicion or without probable cause if it's consensual. You can sit and talk to the people that are parked out in front of the convenience store all day long. They don't have to talk to you. They can get up and walk away, but you have just as much right to be in the parking lot of the convenience store as them. Now, when you do consensually talk to them, something they say may bring you up to a level of reasonable suspicion, or may bring you up to a level of probable cause, in which case your consensual stop has now gone into a detention or into a formal arrest, depending on the circumstances. There are many different levels of proof, going from hunch to reasonable suspicion on up to beyond a shadow of a doubt. To give you a little bit of visual representation of it, kind of think of the scales of justice, if you want, where we've got on one side of the scales we've got innocence or lack of proof, and on the other side we have proof of guilt. So when you start out, there's no crime occurred. There's absolutely no proof of guilt whatsoever. And as you go, you can add a little bit of proof. You're going to start out with a hunch. A hunch is just, I don't know. There's something that he's up to no good. You kind of think of it as that thing that your parents have with their kids. You don't really have any proof that they're doing something, but when they're not making any noise, you have this little hunch that something's going on back there. It's definitely not proof, but you kind of suspect something. You can't stop someone based on a hunch, unless it's a consensual stop. But you can kind of, without detaining them, you can delve a little bit further. And as you go, you add a little bit more proof. You may come up to the level of reasonable suspicion, which is the level that you have to detain them. You may come up to the level of probable cause, which is the level you need to arrest them. You may come up to the level of a preponderance of the evidence, which is where there's a little bit more proof one way than the other, something that we use in civil cases. Clear and convincing evidence a little bit further. Finally, you get to beyond a reasonable doubt, which is the level of proof we're going to need to convict somebody. And if you keep going, you'll eventually come to a level where we call beyond a shadow of a doubt, where there's just no doubt. And pretty much for that level, you're going to have the jury witness the crime. That's not going to occur. We don't need it in a criminal case, so it's it's there. You may see sometimes on TV movies they talk about beyond a shadow of a doubt. Well, that's just an overstatement. Okay, first we'll talk about reasonable suspicion. As I remember, this is what you need when you're going to stop someone, to detain them while you further investigate. And it came out of a ruling in the courts, or was defined more or less in a ruling in Terry versus Ohio. It said where reasonable suspicion requires articulable and individualized suspicion that a crime is afoot. A mere guess or hunch is not enough to constitute reasonable suspicion. So articulable means you have to be able to put it in words. You have to be able to write it down. You have to say, I know he's doing something, but I can't put my finger on what he's doing. No, you have to be able to go beyond that. You have to say, this guy's in a place where he shouldn't be. This guy, he's not dressed right for the area. There's something that's a little bit there. In case in point's this individual. If you look real closely, we're on patrol. It's July. We're in Alvin, Texas, and we're patrolling at 3 o'clock in the morning in the business district. There aren't many people out and about at 3 o'clock in the morning in Alvin, period, much less walking around in the business district. And again, it's July. Look at this individual. What do you see? Well, one, he's wearing a hoodie. Why would you do that? Other than to maybe disguise yourself somewhat. And if you look closely at his hands, what does he have on his hands? Yep, those are socks. How many people do you know that wear socks on their hands? Why would someone wear socks on their hands? Well, I know from experience, being a police officer for many years and being involved in many arrests of individuals who had socks on their hands, they're usually trying to break into something. They're wearing the socks to keep their fingerprints from coming on it. I won't say usually. I've never seen anybody arrested wearing socks on their hands that wasn't breaking into something. So that is articulable. I can put it in writing. Hey, I've got this guy in an area where people are not normally walking around. It's at a late hour in a business district. He's dressed in a manner that would make me think he may be a burglar. Now we'll look at probable cause. In one of the cases that defined it would be Carroll versus United States from 1925. It said that probable cause exists where the facts and circumstances within the arresting officer's knowledge, and of which they have reasonable, trustworthy information, are sufficient in themselves to warrant a man of reasonable caution in the belief an offense has been or is being committed. So the key points is, here is, it's the information that the officer has at the time, and it is the information that's enough to warrant a man of reasonable caution in the belief that an offense has occurred. Now, exactly what is a man of reasonable caution? That's kind of a rather subjective, kind of open for interpretation, but you're going to need more than just reasonable suspicion. It's going to have to be a higher level of proof. Now we're back in that parking lot. It's still dark, still 3 in the morning. We've got the suspect detained, not under arrest yet, but we walk around the corner of the building and we find this. We know that this building the door was not pried open an hour ago when we drove through the parking lot, because we had seen it. And at this point, I think I've got enough to arrest this man on suspicion of burglary. I've got probable cause. Do I have enough to convict him? Absolutely not. I'm going to have proof that a burglary occurred. Maybe somebody else broke in and he just happened to walk up dressed like that. But remember, you have, at the level of probable cause, you have going to have less proof of guilt than proof of innocence. So at this point, we don't need enough to convict him. We just need enough to arrest him. And finding him dressed like that at this hour in a burglary that apparently, or break-in that's apparently just occurred, would be a sufficient proof. Next level we're going to talk about is preponderance of evidence, and this occurs when the greater weight of the evidence is on one side. It's more convincing evidence, mainly used in civil proceedings. It's used in certain court hearings for defenses, where we have to prove certain levels of defense or affirmative defenses based on the preponderance of the evidence. Kind of think of it as the scale is tipped a little bit more in favor of guilt than innocence. And think about it. In a civil case, somebody's got to win. So the side that has a little bit more proof than the other is the one that's going to come out ahead. It's not like a criminal case where it's the state against an individual. Civil cases are one individual or company against another individual or company. So you're going to have some type of winner. It's not like, a criminal case where you've got the state, the weight of the proof is on the state, which is much greater. Next level we're going to talk about is clear and convincing evidence. This evidence is highly or substantially more probable to be true than not. Used mostly in cases where there's some kind of civil liberty interest, things like committing somebody to an insane asylum. You're going to have clear and convincing evidence that they're mentally incompetent, not just a little bit more proof, but clear and convincing proof. Also used in child custody cases. If the state's trying to take custody of a child, we're going to want a little bit more proof that they're an unfit parent than just a little bit more than 50%. That's a big deal to take someone's child from them, so we're going to want clear and convincing evidence. Not quite as far as you're going to go to convict someone of a crime, but at a higher level than you were going to need to win a regular civil suit between two different individuals. Finally, we're going to come to, not exactly finally, but the final one that we actually use in a criminal case is beyond reasonable doubt. And beyond reasonable doubt has been defined by the Fifth Circuit Court of Appeals pattern jury instructions as reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such convincing character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. So, if it's something you're going to make a decision, a life-changing decision on, you have to have that level of proof. Proof enough for you to decide to get married or buy a house or take a new job or retire, something of that sort. That level of proof. It's not proof beyond any doubt. It's beyond a reasonable doubt, and there can be reasonable doubt. And we'll go back to our case of this gentleman. Well, when we search him, we find in his pocket a widget. Kind of looks like a watch. Actually is a watch. And this was a burglar coming out of a building in Dickinson, who was arrested by an officer as he walked out of the house and had the watch in his hand. I was near the scene when I went and snapped this shot. But anyway, in our individual, we find property taken from the place. While we were searching him, dispatch calls and said, hey, the alarm just went off at the building at Widges Incorporated. And finally, the owner of the place shows up and pulls the video, and there's a video of the suspect you have in custody inside the building. That's proof beyond a reasonable doubt. I don't think you're going to have any problem getting a conviction in that type case. But again, it's all subject to interpretation by a jury. And finally, really finally, we're going to talk about beyond a shadow of doubt. I've already mentioned it. It's absolutely no doubt remains about something. It's not needed in a criminal case. You're not going to ever get to that level of proof unless the jury witnessed the incident. And if they witnessed it, they wouldn't be eligible to stand on the jury. So it's something we cannot obtain in a criminal case. Well, we had mentioned earlier consensual encounters. A consensual encounter is not considered a constitutional seizure because it's by consent. But you have to remember, either party can terminate the encounter, and that's not considered part of probable cause or reasonable suspicion that the person doesn't want to talk to you. You have to have something else you can articulate. Also, a reasonable person has to be able to understand that they could refuse to speak to you. It's going to depend on what the officer says when you approach. If you walk up to somebody and say, "Can I talk to you for a second? Would you mind showing me what's in your hand? Can I have a minute of your time?" Those are kind of statements that are, that will allow a person to realize that you're not ordering them to do it, you're requesting them to do it. What happens when an consensual encounter becomes a detention, or when it is considered a detention? Well, anytime an officer displays a weapon, use any kind of harsh word or accusatory tone of your voice, or you order somebody to do something, instead of saying, can I talk to you for a minute? And you say, come here, I need to talk to you. Or instead of saying, can I see what's in your hand? You say, open your hands, I need to see what's in there. Don't move. Come over here. Stop. Those things are considered to be non-consensual in nature, and therefore you would need reasonable suspicion in order to detain somebody. Other things that can make them a detention, instead of a consensual event, would be if you block their path. A guy's riding his bike down the street and you pull your patrol car in front of him and block his path. That's not consensual. If you tell them they're a suspect, you see them outside of the convenience store, you walk up to them, start talking to them, say, hey, the reason I'm talking to you is you fit the description of a guy that just robbed the store. Something like that. Once you tell them they're a suspect, then it's not consensual anymore. Or if you put your hands on them, you put your hands on them to pat them down, it's not consensual anymore. You need reasonable suspicion before you can do a pat-down search of an individual. Now, detention occurs when you have reasonable suspicion, and it's based on the facts known to the officer at the time. Not what you find out later on, but what you know then. No Monday morning quarterbacking. And that can go either way. If you didn't have reasonable suspicion and you find out later that he actually did commit a crime, you can't use the information that you obtained from the illegal search to get your reasonable suspicion. But on the other hand, if he's acting suspicious, his heart's beating, he's sweating profusely, and he's in an area where people don't normally go jogging, and you stop him and pat him down, and it turns out he just likes to jog in a strange neighborhood, well, you still had reasonable suspicion at the time, even though now you know that what he did was nothing out of the, maybe a little out of the ordinary, but nothing that was illegal. It's also going to be based on the officer's experience. The more years you have, the more you've done as an officer, the more easily you can articulate your suspicions and say, from my past experience, I know that an individual wearing socks on his hands could possibly be committing burglaries because I've seen many people who have done such. And again, you have to be able to put it into words, articulate it. Detention should be no longer than reasonable. The question is, what is reasonable? If you're stopping someone to, check them because you think they're a wanted person named John Smith, and you stop them and you get up on them and you say, oh, that's not John Smith, the reasonable amount of time is going to be just a matter of seconds. On the other hand, if you stop the individual with the socks on his hands outside that business and you have to wait for a business owner to come down to check and see if the business has been broken into and it takes 30 minutes, that would probably be considered reasonable because you're detaining him until you can further investigate, and you're doing it within reason. Now, if you're going to try to hold him for a week, that would not be considered reasonable. So you have to kind of look at the totality of the situation. Things that will aid you in determining whether you have reasonable suspicion: the suspect's prior records. Of course, if you this is based on officers' experience that the individual has a record. Awareness of recent crime in the vicinity. It could be that just occurred. It could be a crime that's been occurring on an ongoing basis over the last couple of weeks. Being in a high crime area. Evasive conduct, furtive gestures, concealing or attempting to conceal one's identity. Giving you a false name. When you're pulling a car over, you see someone stuffing something under the seat. As you see them, their head bouncing down, their hand moving. The time of day or night. It's 3 o'clock in the morning. A guy's could probably be much more suspicious than the middle of the day. Or third-party information. You can have an anonymous caller call in and say that there's a guy wearing a green shirt with red pants sitting on the corner of 5th and Main selling drugs. We go to that corner and you got somebody that fits that description. That's going to add to your reasonable suspicion. If he says there's a guy standing on the corner selling drugs and doesn't give you enough description, and that's a corner where people stand around all the time, that's probably not going to be enough to add to reasonable suspicion. So it's got to be some specific information. Pretext stops occur when a vehicle is stopped on a traffic offense that they've actually committed, but you're really not stopping them for the traffic offense. You're looking for drugs, usually drugs. You're stopping them to investigate another offense. It's used often looking for drug couriers. You stop a vehicle because their license plate light's out, because they're speeding 5 miles an hour over the speed limit, because they changed lane on the freeway without signaling the intent to change. You really want to try to determine whether they're smuggling drugs, and you're going to do that by talking to them. And you do have probable cause to stop them and talk to them because they've committed a violation of the law. The arrest is valid as long as there was an objective probable cause, even if the officer had a different subjective motivation for making the arrest. So if I arrest you for traffic offense, but I really want to search you for drugs, and as part of the search, bringing you to jail, I'm going to have to have you empty your pockets and make sure you're not bringing any contraband in the jail. If I find something incident to the arrest, I can use it, even if the purpose of arresting you for this traffic offense was really to search you for the drugs. But if I've got a legal arrest on the traffic offense with probable cause, it's still a good arrest, even though I found the drug incident to that. It cannot be motivated by the intent to single out members of a suspect class such as race. So you can't stop everybody that's white, everybody that's black, everybody that's Hispanic, everybody that's Asian, everybody that's male, or everybody that's female, just because of that thing. And you let people of other races go. You can't target an individual. Can't use racial profiling. Exclusionary rule occurs when evidence that you illegally seized by a law enforcement agency is precluded from use in court. So, if you stop someone and you don't have reasonable suspicion or probable cause to search them, or reasonable suspicion to do a pat down for weapons, and you find something, you're not going to be able to use it in court. The whole purpose of the exclusionary rule is to act as a deterrent to keep police officers from violating people's rights. Now, there are a few exceptions to this rule. The inevitable discovery exception occurs when it would be apparent that you're going to find it anyway. For example, you have an individual who you stop illegally, and during your questioning they tell you, okay, I killed my wife and her body's on the side of the road. The exclusionary rule would preclude you to use any evidence you find from that body. But the inevitable discovery exception says if it's in a place where people would have normally found it, on the side of the road, someone would have come along and eventually found it, then you can use it. Problem is, it's not recognized in Texas. We do not allow the use of the inevitable discovery exception, so you got to be real careful about it. Good faith exception occurs when the officer is acting in good faith reliance on a warrant based upon probable cause. Again, there's a faulty warrant usually for a technical reason. You can still use it, the illegally seized evidence, because the officer wasn't really trying to do something wrong. There was a problem with the warrant somewhere that wasn't the officer's fault. It was relied on. For instance, it could be a case where you arrested somebody on a warrant from another city that and then come to find out that warrant had already been served, but not taken out of the computer system.
Well, that concludes this presentation. Next up, we'll be looking at criminal courts, pretrial process, and the exclusionary rule in Chapter 2.